Hello everyone. Welcome to episode 6 of our Legal Tidbits M&A series in Thailand. Today we're looking at closing the deal. In M&A deals, closing is like the climax of the process. It might be thought of as like a wedding day or as the grand finale of a show. But is that all there is? To look into this topic more closely, joining me are M&A partner Panyavith Preechabhan or Taro and our associates Natsuda, Jirapak and Sireethorn, Weerawuthiwong. Let's start with what closing means. Panyavith, what does it mean?
Thank you, Ben. Closing is a culmination of an M&A deal. After all the time spent on due diligence, negotiations, and discussions with officials, the big day arrives. In theory, closing sounds simple. The seller hands over, and the buyer pays and takes over. But in reality, it's not that simple, as we all know. To make closing happen, many things have to be put in place beforehand. And for the buyer, the next stage after closing has to be kept in mind, the post-acquisition integration. For the buyer, closing is not really an end, it's rather a beginning. And yes, to borrow your analogy, like a wedding day, there's a lot of work leading up to it, and there's still more work to be done the day after.
Yeah, and what can affect the process leading up to closing?
The process leading up to closing mainly depends on what's been negotiated beforehand, usually. The parties will usually spell out in their sale and purchase agreement, or the SPA, what must be done before closing and what must be done on the closing date. If the agreement has been carefully drafted, this can help minimize any ambiguities about what has to happen on the closing date.
And looking at what kind of things have to be done to make closing happen, maybe Natsuda, could you please elaborate?
Yes, sure. Usually the due diligence will have uncovered some issues of concern to the buyer, and the buyer will normally require a condition that these issues be fixed before closing can occur. Therefore, the issues uncovered in due diligence can affect the type of conditions required by the buyer and the number of conditions. All this can affect the timing of the closing. In addition to the conditions, the parties will typically need time to follow their own internal procedures to proceed with the closing. So in a typical case, the agreement will provide a gap between signing and closing, which can range from a few weeks to a few months.
And turning now to what sort of conditions we might expect to see, Sireethorn, could you please share your observations?
Yes, sure. The conditions can vary. They could range from obtaining consents from customers and suppliers, obtaining consents from employees, obtaining regulatory approvals of the deal, and rectifying licensing issues.
And turning back to Taro, and what challenges can meeting such conditions present?
Yes, I think one challenge relates to consents. Obtaining consents from customers and suppliers to continue doing business can sometimes be tricky for the seller. That being, the seller might be reluctant to start talking too early to the customers and suppliers due to confidentiality reasons and the desire not to upset the business relationship.
Obtaining consents from employees needs to be handled carefully. Naturally, employees would feel uneasy if they hear news of a pending change of ownership, especially if they hear it from sources outside the company. The seller will need to communicate the change to employees at the right time and in the right manner.
Yes.
And regulatory approvals such as merger clearance or foreign majority shareholding approval can present challenges. The decisions are at the discretion of the authorities and thus outside the parties' control. The parties need to consider what to do if such approval is not forthcoming. For example, agree to postpone closing or walk away from the deal.
If there are several conditions, what can the parties do to manage this?
Yes, the parties will want to set up a process, I think, to monitor the actions being taken to satisfy the conditions, and then verifying that the conditions have been satisfied.
So after doing all the work to fulfill the conditions, is that it, or is there more? Let's ask Natsuda.
There's more. The parties will agree that certain documents need to be delivered on the closing date, called deliverables or closing documents. Commonly, this will include the legal documents that affect the transfer. For example, in case of share acquisition, the buyer will want to check that the share transfer documents show the buyer as the owner, and also check that the application forms to change directors to the buyer are ready to be submitted to the authorities.
And depending on what the parties have agreed to, there might be other related documents that have to be delivered at closing. For example, consents from key customers and suppliers. The buyer will want to verify these two before closing.
I think from our experience, the parties will find it very useful to discuss and plan together for the closing, so that the actual closing day runs much more smoothly. And in this time when people are still working remotely or facing travel restrictions, I think the issue of virtual closing, does come up now and again. And this too can be achieved if the parties discuss and agree beforehand.
Yeah. Okay, let's talk a little bit more about closing logistics. What can the parties do beforehand?
Sure, Ben. Discussing the logistics beforehand is, I think, vital to the closing of the deal. Factors such as time zone differences, bank remittance processes, the opening hours of government offices, and even the parties' physical locations. These can all influence the closing day logistics. The parties will find it useful to spell out in the sale and purchase agreement, as much as they can, what closing means and exactly what actions will have to happen on the closing date. Without close communication between the parties, closing can develop into a chicken and egg situation. So that is, the buyer won't want to make the payment unless it can be assured that the closing documents will be released. And on the other hand, the seller won't want to release the closing documents unless it can be reassured that it will receive payment. So I think coordination with the banks too should be useful to find out how they can help facilitate a smooth transfer of funds, given the different methods that this can be done at this stage, in this time.
Yeah.
Yes, and although the Ministry of Commerce has been digitalizing some processes over the past 2 years, the application for changes of corporate details still needs to be submitted in hard copies and with ink signatures. Therefore, the parties still have to hold closings in person to hand over the closing application documents.
Another factor is the Ministry of Commerce reservation system that it put in place due to COVID-19. To submit an application, the applicant has to reserve a time slot to attend the Ministry of Commerce. This as a time pressure factor to closing days.
Yeah. Some people say that closing is really day one. Taro, what do you think?
Yes, I think I do agree with that statement. Once closing happens, the buyer has to implement its post-acquisition integration plan. So that means, for the buyer, it's day one of post-acquisition integration. So ideally, the buyer would have already started planning long before closing for day one and after. Several aspects of the target's business, like its employees, contracts, compliance policies, need to be integrated into the buyer's business. So we'll look at this in more detail in another episode.
Yeah, thank you. Well, that's all we have time for now. Today we've looked at closing a deal and some of the issues to watch out for. Now, please join us for the next episode, which will be on post-acquisition integration. Thank you.
Thank you.